This is the brief on the Philippine Act on Crimes Against International Humanitarian Law. Republic Act 9851 essentially takes heavy global treaties, like the Geneva Conventions, and gives them absolute teeth within the Philippine justice system, so the world's worst crimes don't go unpunished. First, this law takes international atrocities, we're talking war crimes, genocide, and crimes against humanity, and brings them right down to street-level enforcement. We're looking at severe consequences here, hitting perpetrators with reclusion perpetua, meaning life behind bars, plus massive fines hitting up to 1 million pesos. Second, who actually faces these penalties? Well, pretty much everyone. Badges, military ranks, or political titles offer zero protection, with just a narrow exception for the sitting president. Bosses are strictly liable for their subordinates, and get this, there's absolutely no statute of limitations. Now you might be wondering, what if they were just following orders? Well, that classic excuse is totally useless if the command was manifestly unlawful, like orchestrating a genocide. Finally, where exactly does this apply, and what happens to the victims? The jurisdiction is massive. So, can a foreign war criminal just hide out in Manila? No way. Simply stepping foot in the Philippines triggers the law, just as if the accused or victim were Filipino. And while the courts cast this huge net to catch offenders, they fiercely protect the victims, guaranteeing things like closed-door trials for kids and forcing the convicted to pay out direct financial reparations. Ultimately, this law acts as a massive legal net, ensuring humanity's worst offenders literally have nowhere to hide. True justice respects no borders, and under this legislation, accountability never expires.
Welcome to Architecting Justice, the Republic Act 9851 dossier. This video outlines the Philippine framework for prosecuting serious international crimes like international humanitarian law violations, genocide, and crimes against humanity. It serves as a visual guide to jurisdiction, criminal liability, and victim protection. The core principle of RA 9851 is that the most serious crimes must not go unpunished to end impunity. The Act integrates international laws, prioritizing the Hague and Geneva Conventions. It ensures the protection of the vulnerable and guarantees a fair trial with accessible, gender-sensitive avenues of redress. The extraterritorial reach of RA 9851 employs universal jurisdiction. The state can prosecute a crime regardless of where it was committed if the accused is a Filipino citizen present in the Philippines or the victim is Filipino. Exclusive original jurisdiction falls to designated special courts within the regional trial court. The triad of atrocity defines 3 main crime categories. War crimes require a context of armed conflict and the intent to violate military necessity. Genocide can occur during peacetime or armed conflict, requiring the intent to destroy a stable group. Crimes against humanity require knowledge of a widespread or systematic attack against any civilian population. Diagnosing the conflict involves distinguishing between international armed conflict, or IAC, and non-international armed conflict, or NIAC. IAC involves 2 or more states, while NIAC is between governmental authorities and organized armed groups within a state. Both involve protracted armed violence, excluding riots or isolated acts of violence. War crimes are categorized into crimes against persons, property, and institutions, and prohibited methods of warfare. These include willful killing, taking hostages, attacking undefended towns, using poison, and conscripting child soldiers. The architecture of genocide centers on the intent to destroy a group. Prohibited acts include killing members, causing serious harm, inflicting destructive conditions, preventing births, or forcibly transferring children. Direct public incitement to commit genocide is also a distinct, unlawful offense. Crimes against humanity are defined by the core requirement: acts committed as part of a widespread or systematic attack against any civilian population with knowledge of the attack. These crimes are grouped into deprivation of life or liberty, systematic oppression, and physical or psychological violence. The web of liability outlines modes of participation. The principal commits the crime. The accomplice facilitates it by aiding or assisting. The attempt involves taking a substantial step towards execution. Voluntary abandonment of the criminal purpose is an exemption that prevents liability. Command responsibility dictates that liability flows upward. Superiors, whether military commanders or civilian authorities, are liable as principals for crimes committed by subordinates if they had effective command and control, knew about the crimes, and failed to take necessary and reasonable measures to prevent or prosecute them. The inescapable net dismantles traditional defenses, the status defense based on official capacity, and the time defense regarding non-prescription of crimes are invalidated. Time does not erase liability, and status does not exempt a person from liability. The superior orders filter determines criminal liability for subordinates. If an order results in genocide or a crime against humanity, it is manifestly unlawful, and the subordinate is criminally liable. Only if all conditions regarding legal obligation, knowledge of unlawfulness, and manifest unlawfulness are met, is the subordinate relieved of responsibility. The price of atrocity outlines the penal provisions. Standard penalties involve reclusion temporal and fines up to PHP 500,000. Maximum penalties for extreme gravity include reclusion perpetua and fines up to PHP 1 million. Incitement to genocide carries prison mayor. Asset forfeiture is mandated for proceeds and property derived from the crime. The protective shield ensures the safety of witnesses and provides redress. Protection measures include in-camera proceedings, electronic evidence presentation, and withholding summaries of evidence if disclosure endangers a witness's family. Victims are entitled to reparations, restitution, compensation, and rehabilitation mandated by court orders. RA 9851 provides a completed architecture for justice. It establishes universal jurisdiction, defines the triad of crimes, ensures inescapable liability, and mandates victim protection. This framework ensures the most serious crimes of concern to the international community do not go unpunished.
All right, today we're jumping into a really significant piece of legislation from the Philippines, Republic Act 9851. Now, this isn't just any law. It's a powerful tool designed to go after the most serious crimes you can imagine, and to make sure that the people who commit them, no matter how powerful they are, have absolutely nowhere to hide. And that really brings us to the core question here, doesn't it? When these unthinkable acts happen, how does a country actually build a legal system to hold people accountable? Well, that exact challenge is what RA 9851 was created to address.
So at its heart, the entire purpose of this law can be boiled down to fighting one thing: impunity. And impunity is just a fancy word for getting away with it, right? Exemption from punishment. This law is basically the Philippines drawing a line in the sand and saying, for these crimes, there are no free passes.
And hey, don't just take my word for it. This is pulled straight from the law itself. It's like its mission statement, written right into the text. The goal couldn't be clearer: put an end to impunity, make sure people are prosecuted, and hopefully prevent these horrible crimes from ever happening again. You know, this law didn't just appear out of nowhere. What it does is it takes all these international rules on war and human rights that have been built up for decades, things you've probably heard of, like the Geneva Conventions, and it makes them fully part of the Philippine legal system. It brings international justice home. So what are we actually talking about when we say the most serious crimes? Well, the law is super specific, and it breaks them down into three main categories. Let's dive into the first one, which is probably the most familiar to all of us: war crimes. Okay, so war crimes. The list is pretty long, but the central idea is all about protecting people who aren't in the fight or who are no longer fighting. We're talking about things like willful killing and torture, of course, but also deliberately attacking civilian places like schools and hospitals. It even makes using starvation as a weapon of war a crime you can be prosecuted for. And this brings us to a really key legal idea: hors de combat. It's a French term that literally means out of the fight. The law is crystal clear on this. Anyone who has surrendered, is wounded, or is just defenseless for any reason, they are protected. Attacking them is a war crime, plain and simple. And the law goes even deeper. It's not just about protecting people, it also regulates the methods of war. So it's not just about who you can't attack, it's about how you can't fight. This means banning sneaky tactics like perfidy, or using civilians as human shields, and even using certain prohibited weapons. Let's look a little closer at that word, perfidy. What is it? It's basically the act of betraying an enemy's trust to get a military advantage. So think about faking a surrender just to launch an attack, or misusing a white flag of truce. This is damned because it just completely destroys the basic rules of engagement that are there to make conflict even a tiny bit less brutal. Okay, the second major category is genocide. And the key word here, the absolute crucial element, is intent. We're talking about the specific intent to destroy a national, ethnic, racial, or religious group. As you can see, it's not just about killing. It covers a whole range of acts that are all tied together by that one terrible, destructive goal. And finally, we have other crimes against humanity. Now, what turns these awful acts like extermination or enslavement or apartheid into this specific category is the context. They have to be part of a widespread or systematic attack against civilians. So we're not talking about isolated incidents here. We're talking about things that are part of a larger, organized policy. So we've defined the crimes. The next big question is, who's on the hook? Who gets held responsible? Well, this law sets up a really powerful system for accountability that goes from the soldier on the ground all the way up to the head of state. The law really lays out two main kinds of responsibility. First, you've got individual responsibility. That's pretty straightforward. The person who commits the crime, orders it, or helps out is liable. But just as important is something called superior responsibility. And that means a commander can be held accountable for what the people under their command do.
And let's be really clear about what superior responsibility means. It isn't just about giving the orders. A commander is on the hook if they knew or frankly should have known that their troops were committing these crimes and they did nothing to stop or punish them. I didn't know isn't a defense if you chose to look the other way.
And this might just be the law's most powerful part. How many exemptions are there for your official position? 0. A big fat 0. It doesn't matter if you're a general, a government official, or even a head of state. Your title does not give you a get-out-of-jail-free card. Nobody is above this law. The law also takes on that classic excuse, I was just following orders. And it says, nope, that's not a defense if the order was manifestly unlawful. I mean, in order to commit genocide or a crime against humanity, it's obviously illegal. There's no gray area there. And this is so important. There's no expiration date on justice here. The clock never runs out. Prosecution for these crimes can't be blocked just because a lot of time has passed. This means perpetrators can be held accountable years, even decades later, which gives victims hope that justice might still be possible. Okay, so punishing the perpetrators is one side of the coin. But what about the people who have suffered through all this? Well, the law puts a huge emphasis on delivering justice for the victims too. The Act actually requires courts to take specific steps to protect victims and witnesses. They have to make sure they're safe, that their dignity is respected, and that their privacy is protected. This can mean things like holding private hearings and, critically, making sure the victim's own views and concerns are actually heard and considered by the court. And as you'd expect, the penalties are incredibly severe because the crimes themselves are so grave. We're looking at everything from long-term imprisonment all the way to life in prison for the most extreme offenses. The message here is loud and clear. If you commit these acts, you will face the most serious consequences possible. But justice here means more than just a prison cell. The court can actually order someone who's been convicted to provide reparations to their victims. This could be restitution, compensation for what they lost, and even rehabilitation to help them try and rebuild their lives. It's about trying to repair some of the incredible harm that was caused. So, at the end of the day, why does this all matter? Because Republic Act 9851 is a powerful statement. It takes these huge principles of international justice and makes them real and enforceable in Philippine courts. It's a vital, powerful legal tool in the fight against impunity, making sure justice isn't just some abstract idea, but something that can be delivered at home. And that kind of leaves us with one final big question to think about. A law like this is an incredible statement of principle, but the real challenge for any country is, how do you make sure that the words on the page actually turn into real, true justice on the ground for the people who need it most?
So I want you to close your eyes for just a second and try to imagine the absolute primal chaos of a battlefield.
Yeah, that is an intense image right off the bat.
It is, right?
Yeah.
But just picture the overwhelming noise, the confusion, the adrenaline. You are looking at an environment where human beings are actively and aggressively employing every tool they have to end each other's lives.
Right, it's pretty much the ultimate breakdown of normal society.
Exactly. And when you strip away the politics, and you just look at that level of localized, organized violence, a really fundamental question comes up.
Which is?
Well, in a situation where the entire objective is to kill the enemy, is it even possible to have, like, actual rules?
I mean, it sounds like an inherent contradiction, doesn't it?
It totally does.
Because the idea of a structured, binding rule book for literally the most violent, lawless environment imaginable, it kind of defies our basic intuition.
Yeah, we usually associate the concept of law with, quiet courtrooms or orderly city streets.
Right? Or legislative chambers. We definitely don't picture the law existing in the mud and the blood and the sheer panic of a war zone.
And I think the human brain just wants to treat this as a binary. Like, either we are sitting in civilization governed by rules, or we have descended into war and total chaos.
But then you start studying the history of international humanitarian law, and you realize something pretty incredible.
Which is that humanity has spent centuries stubbornly trying to draw lines in that mud.
Exactly. We are looking at a legal landscape that is this incredibly fascinating attempt to define the undefinable, to basically put a leash on the worst impulses of our species.
And welcome, by the way, to today's deep dive, where we are going to explore exactly that. We are digging into Republic Act number 9851.
Also known as the Philippine Act on Crimes Against International Humanitarian Law, Genocide, and Other Crimes Against Humanity.
Yeah, passed back in 2009. And I have to say, this document is one of the most compelling pieces of legal architecture you will ever come across.
It really is. And what makes it so unique, for you listening, is that it operates as a bridge.
A bridge between international and domestic law, right?
Precisely. It takes the most universally agreed upon principles of international law. The concepts drafted in Geneva and The Hague over the last century, and it hardwires them directly into a single nation's domestic legal system.
But I have to ask, why do we even need a bridge? Like, if 100 nations sign the Geneva Conventions, doesn't that international law just inherently apply everywhere?
Well, you would hope so, but international law operates in this sort of diplomatic ether.
What do you mean by ether?
I mean that a treaty is, at its core, just a promise between sovereign nations. It's an agreement on paper.
Okay.
But for a local police officer to actually kick down a door and make an arrest, or for a local judge to bang a gavel and hand down a life sentence, they need domestic jurisdiction.
Right. They need a law on their own local books. They can't just cite a UN charter to lock someone up in a municipal jail.
It's exactly the issue. So what this specific legal framework does is it takes those grand international concepts like the duty to protect victims or the pledge to punish war crimes and gives them sharp, localized teeth.
It empowers the domestic justice system to enforce the conscience of the international community.
That's a great way to put it.
So, to understand how this law attempts to hold the powerful accountable and protect the vulnerable when society breaks down, we really have to start at the foundation.
Right, because before you can throw a general in prison for a war crime, you have to define the boundaries of war itself.
And the law goes to great lengths to establish this highly specific vocabulary of conflict, starting with the very definition of an armed conflict.
Yes, because it's not just any time people are shooting at each other.
Right. Precision here is quite literally a matter of life and death. The text deliberately differentiates between actual armed conflicts and what it classifies as mere internal disturbances or tensions.
And that threshold is incredibly important. An armed conflict might be an international war between two sovereign states, or a non-international conflict between a government and a highly organized armed group.
So I assume that distinction leaves out things like, spontaneous riots or isolated acts of gang violence.
It does. Think of a massive, violent riot in a city center.
Okay, I'm picturing it.
That is terrifying, and it involves a lot of violence, but it is fundamentally a matter for domestic criminal law and the police force.
So it doesn't trigger the laws of war.
Exactly. To cross the legal threshold into an armed conflict, there must be a level of sustained organization. The armed forces involved need a command structure, an internal disciplinary system, and the ability to sustain protracted military operations.
Wow, okay. And once that threshold is crossed, the normal rules of peacetime law are basically suspended and the laws of war take over.
Right, which introduces one of the most debated concepts in the entire framework, which is military necessity.
Oh man, military necessity. When you first encounter that phrase, the immediate cynical reaction is to think, well, if a general wants to win a war, isn't literally everything a necessity to them?
And the architects of humanitarian law anticipated that exact cynical justification.
They saw that coming.
Oh, absolutely. Which is why the legal definition of military necessity acts as this severe filter. The law defines it as employing only those measures which are indispensable to achieve a legitimate aim of the conflict.
And crucially, those measures cannot be otherwise prohibited by international law. But that word indispensable, it carries a lot of weight there.
It really does. It implies a total lack of alternatives. It strips away convenience.
Give me an example of how that works in practice.
Okay, so if an advancing army wants to secure a river crossing, and there's a bridge held by enemy combatants, destroying that bridge might be a military necessity.
Because they have to stop the enemy's movement.
Right. But if the army blows up the bridge just to punish the local civilian population or out of pure spite or just to test a new explosive, that crosses the line.
It becomes wanton violence.
Exactly. It must be absolutely essential to a legitimate military objective.
And defining what you can target naturally leads to defining who you cannot target.
Yes, the protected categories.
Right. The law carves out this massive protective bubble using a very specific French term, hors de combat.
Which translates literally to outside the fight.
Outside the fight. And this concept is essentially the heartbeat of humanitarian protection.
It really is. It applies fundamentally to anyone who is in the power of an adverse party, like a captured prisoner of war.
But its reach is much broader than just POWs.
Yes, definitely. It covers a soldier who has clearly expressed an intention to surrender or someone who has been rendered unconscious.
Or incapacitated by severe wounds or sickness, meaning the moment they are incapable of defending themselves, their status legally shifts.
Exactly. If a soldier drops their weapon, raises their hands, and abstains from any hostile act, they are no longer a combatant.
They step out of the crosshairs and into the category of a protected person.
Because the military objective, which was neutralizing the threat that soldier posed, has already been achieved.
So to shoot them after that point serves no indispensable military purpose. It is simply murder.
Correct. But the protection of that hors de combat bubble seems, well, incredibly fragile.
Very fragile, which explains why the law comes down with absolute fury on a concept called perfidy.
Ah, perfidy. This is a big one.
It is. Now, perfidy is often summarized as just lying in war, but the legal definition is far more sinister than that.
Much more. It describes acts that invite the confidence of an adversary, making them believe they are entitled to protection with the explicit intent to betray that confidence.
So it is the calculated weaponization of human trust.
That is exactly what it is. And the text outlines several grim examples of this.
Like feigning an intent to negotiate under a flag of truce.
Right. Or faking surrender, pretending to be incapacitated by wounds, or misusing the protective emblems of the Red Cross or the United Nations to launch a surprise attack.
Okay, so I have to push back on this a bit, or at least channel the skepticism a lot of listeners might have right now.
Go for it.
Because in almost any competitive arena, deception is just considered a strategy.
Sure.
Like if you watch a basketball player fake an injury to draw a foul, or a football team run a trick play, it's just part of the game.
Right.
And even in warfare, camouflage and dummy tanks are perfectly legal.
They are?
So why is faking a white flag elevated to the level of a supreme war crime, categorized right alongside mass violence? Isn't tricking the enemy just outsmarting them?
It's a great question. But distinguishing between a lawful ruse of war, like the dummy tanks you mentioned, and illegal perfidy requires us to look at the catastrophic secondary effects of the crime.
Okay, lay it out for me.
Let's map out the psychology of a perfidious attack. Imagine a squad of soldiers finds themselves pinned down. They raise their hands and wave a white flag.
The universal symbol of surrender.
Exactly. The opposing forces see that symbol, step out from their cover, and lower their weapons to take prisoners. But the moment they are exposed, the surrendering squad pulls concealed weapons and slaughters them.
A highly effective, if completely brutal, ambush.
Highly effective in the short term, yes. But think about the structural damage to the conflict itself. What happens a week later when a different group of soldiers genuinely tries to surrender to that same opposing force?
Oh, they won't believe them.
No, they won't.
The opposing force will look at that white flag, remember the ambush, and they'll just open fire.
Precisely. The mechanism of mercy has been entirely destroyed. Perfidy doesn't just kill the soldiers in that specific ambush.
It signs the death warrant of every combatant who might genuinely need to surrender in the future.
Exactly. If a sniper uses a clearly marked ambulance to sneak into a city, the enemy will start bombing ambulances. Perfidy forces the conflict into a no-quarter scenario.
And declaring that no quarter will be given, meaning an army publicly states they will refuse to accept surrenders and will simply execute everyone, is explicitly listed in this law as a massive war crime.
Because it returns warfare to a state of absolute, unregulated barbarism.
Right. The laws of war rely on a shared vocabulary of trust. The white flag, the medical cross, the raised hands.
And if you pollute that vocabulary with lethal deception, the entire architecture of humanitarian protection collapses.
Wow. Which perfectly sets up the transition into how this law categorizes the darkest acts imaginable.
We are moving into Chapter 3 now.
Yes, dissecting the three major categories of crimes. Because once those boundaries of lawful warfare are drawn, what does it legally look like when an army sprints past them?
This framework divides the worst atrocities into three distinct pillars: war crimes, genocide, and crimes against humanity.
And it is so vital we explore these deeply, because these terms, they get thrown around interchangeably in the news all the time.
They do, but in a courtroom, they have incredibly rigid, distinct requirements. The burden of proof shifts dramatically depending on which category you invoke.
Let's start with war crimes. By their very nature, they require the existence of an armed conflict, right?
Yes, that is the prerequisite. And the law provides a sweeping, chilling catalog of prohibited acts under this section, heavily focused on the targets of violence.
Intentionally directing attacks against the civilian population is the foundational prohibition.
Right. But it also gets highly specific about infrastructure. The text explicitly outlaws launching attacks against works and installations containing dangerous forces.
And it singles out dams, dikes, and nuclear electrical generating stations, which makes total sense.
The rationale there is rooted in physics and causality. When you breach a massive hydroelectric dam or compromise the containment of a nuclear reactor, you are no longer controlling the weapon.
You are unleashing a catastrophic secondary force, a wall of water or a radioactive plume.
Exactly. And that secondary force is inherently indiscriminate. It cannot distinguish between a military barracks and a civilian kindergarten.
The damage cascades far beyond the initial explosion.
It does. And the law is equally strict about the methods of warfare, regardless of the weapons used.
Like criminalizing the intentional use of starvation as a weapon of war.
Yes, by depriving civilians of objects indispensable to their survival. Burning crops, poisoning wells, blocking food shipments.
Because historically, siege warfare often relied on starving a population into submission.
But modern humanitarian law completely outlaws that strategy if it targets the civilian population. The goal is to isolate the military objective without orchestrating a famine.
Now, speaking of weapons, there is a really technical provision in this law that caught my attention.
Which one?
We all know biological weapons and asphyxiating gases are banned, but the text specifically prohibits the use of bullets, which expand or flatten easily in the human body.
Ah, yes, bullets with hard envelopes which do not entirely cover the core.
Exactly. Why is that so specific?
Well, this takes us deep into the history of military technology. It traces back to the Hague Declarations of 1899.
Wow, that long ago.
Yes, it addresses the fundamental philosophy of why a soldier fires a weapon. Under international law, the legitimate purpose of shooting an enemy combatant is simply to neutralize them.
To take them out of the fight, so they become hors de combat.
Right, and a standard full metal jacket bullet generally achieves that. It passes through the tissue, incapacitates the target, and forces them to receive medical care.
But a hollow point, or an expanding bullet, is engineered with a completely different physical objective.
Exactly. Upon entering human tissue, it mushrooms outward, creating a massive, jagged wound channel.
It transfers all its kinetic energy directly into destroying organs and shattering bones. So it's not designed to neutralize, it's designed to obliterate.
Yes. It ensures that even if the soldier survives the initial impact, their recovery is nearly impossible, or their death is agonizingly prolonged.
And the legal term for that is inflicting superfluous injury or unnecessary suffering.
Right. If a standard bullet satisfies the military necessity of stopping the threat, then engineering a bullet specifically to cause unrecoverable trauma crosses the line from combat into cruelty.
It is profound to realize that even in the brutal business of killing, the law demands a baseline respect for the human body.
It really is. And we see a similar baseline drawn around the psychological capacity of combatants, particularly regarding child soldiers.
Yeah, the recruitment and use of children in hostilities is one of the most heavily scrutinized war crimes.
The law establishes rigid age lines here. It is a crime to conscript children under the age of 15 into national armed forces.
And for non-state armed groups, the prohibition extends to anyone under 18.
The distinction recognizes that a child simply cannot provide informed consent to endure the horrors of combat.
Their psychological development makes them uniquely vulnerable to indoctrination. And placing a rifle in their hands steals their fundamental right to a childhood.
Absolutely. But as horrific as war crimes are, the law places a completely different framework around the second pillar.
Genocide, the crime of crimes.
Yes. And the defining characteristic of genocide, and the reason it is so notoriously difficult to prosecute, is that it requires a very specific legal element.
Right, something called dolus specialis.
Exactly, special intent. This is where the law literally looks inside the perpetrator's mind.
The text defines genocide as acts committed with intent to destroy, in whole or in part, a national, ethnic, racial, religious, social, or any other similar stable and permanent group.
So think about it this way. A military commander might order the ruthless carpet bombing of a city, resulting in tens of thousands of civilian deaths.
That is undeniably a horrific war crime, and probably a crime against humanity.
Yes. But unless the prosecutor can prove the commander ordered the bombing specifically to wipe out a particular ethnic or religious group residing in that city, it is not legally genocide.
The intent to erase the group's existence must be the driving force.
It must be. And the methods of erasure aren't limited to mass executions.
Right. Killing members of the group is just the first act listed. It also includes deliberately inflicting conditions of life calculated to bring about the group's physical destruction.
Like forcing an entire population into a barren desert without water.
But it also includes profound demographic manipulation, which I find deeply unsettling.
You're talking about imposing measures intended to prevent births.
Yes, and forcibly transferring the children of the group to another group. That is so insidious.
It is the systemic, quiet destruction of an identity.
Because you don't have to build a single camp or fire a single bullet to commit genocide. If you systematically sterilize a population, or if you rip their children away from their families to be raised by a hostile culture, you achieve the exact same goal.
You are erasing a culture by stealing its future. You sever the generational continuity that defines an ethnicity.
And the law recognizes that a crime of this magnitude doesn't happen in a vacuum. It requires societal preparation.
Which is exactly why the law uniquely singles out incitement. It is a standalone crime to directly and publicly incite others to commit genocide.
Meaning, you don't even have to pull a trigger. If you sit behind a microphone at a radio station and systematically urge your listeners to view their neighbors as vermin that need to be exterminated, you are guilty under this act.
Because history proves that the path to genocide is always paved with orchestrated propaganda. The law attempts to criminalize the spark before it becomes a wildfire.
This brings us to the third pillar, which is crimes against humanity. How does this category plug the gaps left by war crimes and genocide?
Well, the most critical distinction is the context. War crimes require an active, legally defined armed conflict.
Right.
Crimes against humanity do not. A government can commit crimes against humanity against its own citizens during a time of total peace.
That significantly expands the jurisdiction of the law, but I imagine the threshold for what constitutes the crime has to be incredibly high.
Oh, it is. Otherwise, every domestic murder would be an international incident.
Right. So what is the threshold?
It's about scale and organization. To qualify, the acts must be committed as part of a widespread or systematic attack directed against any civilian population with knowledge of the attack.
Widespread or systematic. So a prolific serial killer terrorizing a city isn't committing a crime against humanity because they are acting alone.
Exactly. But if a state intelligence agency orchestrates a policy to torture political dissidents, that crosses the line.
And the acts listed include things like extermination, enslavement, arbitrary deportation, and rape.
But it also explicitly names structural crimes, like apartheid.
Which is defined as inhumane acts committed to maintain an institutionalized regime of systematic oppression by one racial group over another.
Another incredibly specific, psychologically devastating crime listed here is the enforced or involuntary disappearance of persons.
Yes, the law defines this as a state or a political organization arresting or abducting individuals and then flatly refusing to acknowledge the deprivation of freedom.
Or refusing to give any information on their fate. The cruelty of an enforced disappearance is multifaceted. The victim is entirely removed from the protection of the law.
Left entirely at the mercy of their captors.
But the secondary victims are the families.
Because the families are trapped in this agonizing limbo. They don't know if their loved one is dead or if they're suffering in a black site or if they will walk through the door tomorrow.
It paralyzes entire communities with an ambiguous, suffocating fear. It really is a weaponization of uncertainty.
The law also categorizes forced pregnancy as a crime against humanity.
Yes, defining it as unlawfully confining a woman and forcibly making her pregnant, explicitly with the intent of affecting the ethnic composition of a population.
Which violently bridges the gap between a crime against humanity and the demographic manipulation we discussed under genocide.
It shows how these legal categories bleed into one another in the most terrifying ways. They form this overlapping net designed to catch every conceivable iteration of state-sponsored atrocity.
Okay, I have a major hypothetical I want to throw at you now.
I'm ready.
Because this is where the theory of law crashes into the horrifying reality of combat. We have established the rules. We know a military cannot intentionally target civilians or hospitals.
Right.
But let's say an insurgent group intentionally hides a massive critical munitions depot in a subterranean bunker directly beneath a fully functioning civilian hospital.
A classic, terrible scenario.
Right. And the state military knows the weapons are there. And they know destroying those weapons is absolutely vital to winning the war.
Oh, okay.
If the commander orders an airstrike on that hospital to hit the depot knowing civilians will die, is that commander automatically guilty of a war crime?
You've just described the most agonizing, intensely debated moral and legal dilemma in all of international humanitarian law.
I figure there has to be some sort of legal math happening here, because clearly the law doesn't give insurgents a free pass to win a war just by strapping hostages to their tanks.
You're right. The law does not grant immunity through human shields. But it does place an immense burden on the attacking commander through a deeply uncomfortable concept known as the principle of proportionality.
Okay, what does that look like?
The text states that it is a crime to launch an attack in the knowledge that it will cause incidental loss of civilian life or damage to civilian objects, which would be excessive in relation to the concrete and direct military advantage anticipated.
Excessive in relation to the concrete and direct military advantage anticipated. That literally implies the commander has to weigh human lives against military value on a scale.
It is a profoundly dark calculus. Let's break down your hypothetical.
Okay.
If the subterranean bunker only holds a few crates of obsolete rifles, and the airstrike would collapse the hospital and kill hundreds of doctors and patients.
The civilian harm is clearly excessive compared to the minor military advantage.
Exactly. Ordering that strike is a war crime.
But what if the bunker holds a battery of long-range missiles that are actively being prepped to launch at a populated city center?
In that scenario, the direct military advantage anticipated, which is preventing the imminent destruction of a city, is massive.
Right.
The commander must make a real-time, high-stakes calculation based on the intelligence available. If they authorize the strike and the resulting civilian casualties in the hospital are deemed proportionate to the military threat neutralized, it may be a lawful attack, despite the horrifying loss of life.
Man, that places an unimaginable moral weight on the shoulders of military leadership. You are essentially asking a human being to assign a numerical value to a civilian life.
You are.
Which leads us perfectly into the next major question of this deep dive, liability.
Yes, chapters other V.
Because when that dark calculus is wrong, or when a battalion completely loses its moral compass and burns a village who actually goes to prison, do we punish the young soldier holding the match, the general staring at a map, or the president who declared the war?
The concept of individual criminal responsibility for mass, collective violence is incredibly complex. The law has to establish a chain of liability that ensures nobody can hide behind the bureaucracy of war.
Well, the penalties themselves are definitely severe. The baseline punishment for these acts is reclusion temporal, which is a heavy prison sentence and significant fines.
But it escalates quickly. If the crime results in death, serious physical injury, or involves rape, the penalty jumps to reclusion perpetua.
Which effectively means life imprisonment, alongside fines up to 1 million pesos, and the total forfeiture of all assets derived from the crime.
But the true power of this framework isn't just the length of the sentence, it's who it applies to. The law explicitly establishes the irrelevance of official capacity.
Meaning it states that being a head of state, an elected representative, or a high-ranking government official does not exempt you from criminal responsibility.
Nor does it even constitute grounds for a reduced sentence. Historically, leaders who orchestrated genocides or systemic oppression hid behind the doctrine of sovereign immunity.
They argued that because their actions were acts of state, ordinary courts had no jurisdiction over them.
Exactly. But this law categorically destroys that shield. While there may be temporary constitutional immunities while a president is in office, Their title does not wash away the criminality of their actions.
So once they step down, or if the international community intervenes, they are as liable as anyone else.
Yes, they are.
Okay, so the politician in the capital can't hide behind a title, but let's move down the chain to the military commander.
This brings us to the responsibility of superiors.
Right. The law says a commander is criminally responsible for the crimes committed by subordinates under their effective control. But surely it can't be strict liability, right?
What do you mean?
Well, if a general is managing a front line of 50,000 troops and one rogue squad loses its mind and commits a massacre in the middle of the night, you can't automatically hang the general, can you?
You cannot. The prosecution must prove a specific level of awareness and negligence. The commander is guilty if they either knew or, owing to the circumstances at the time, should have known that the forces were committing those crimes.
Should have known. That is a fascinating legal standard.
It is. How do you visualize it?
I think of it like the CEO of a massive chemical corporation.
Okay.
If one of their factories is dumping toxic waste into a local river, the CEO can't just lock themselves in a boardroom, intentionally ignore the environmental impact reports, refuse to audit the factory, and then claim, well, I didn't personally open the valve, so I'm innocent.
That analogy tracks perfectly with the military doctrine of command responsibility. If a commander creates a culture of impunity, ignores reports of civilian casualties, fails to discipline soldiers for minor infractions, and generally turns a blind eye to the conduct of their troops.
They fulfill the should-have-known criteria.
Yes. If they had the material ability to prevent the crimes or punish the offenders, and they failed to take necessary and reasonable measures, they are legally considered a co-author of the atrocity.
The law demands proactive leadership. Looking the other way can literally land you in prison for life.
It can.
So that covers the boss. Let's look at the absolute bottom of the hierarchy. What about the 18-year-old private who is handed a rifle and given an order?
The classic Nuremberg defense. I was just following orders.
Right. How does the law address orders from a superior?
It restricts that defense to an incredibly narrow set of circumstances. Committing a war crime because a superior ordered you to does not relieve you of responsibility unless 3 criteria are simultaneously met.
Okay, what are they?
You must have had a legal obligation to obey, you must not have known the order was unlawful, and the order itself must not have been manifestly unlawful.
Okay, I really have to challenge the practicality of this. Let's look at the psychological reality of a military structure.
Go on.
You take young recruits and you drill into them day and night that obedience to a commanding officer is absolute. And in a combat zone, disobeying a direct order can be classified as treason or mutiny, which carries the threat of a firing squad. Isn't the law demanding an impossible, almost suicidal level of moral courage from a terrified private?
It is an incredibly heavy burden, yes. But let's examine the alternative.
Yeah.
If I was following orders as accepted as a blanket defense, then nobody in an entire army is guilty of a crime except the one supreme commander at the very top who issued the initial directive.
So tens of thousands of people could participate in a genocide and only one person would go to jail.
Exactly. That would completely nullify the concept of justice.
Yeah, that makes sense.
This is why the concept of a manifestly unlawful order exists. It acts as the ultimate moral circuit breaker.
Okay, explain how that circuit breaker works.
If an officer orders a soldier to charge a heavily fortified machine gun nest, the soldier must obey. It might be a tactically foolish order, it might be suicidal, but it is a lawful military command.
Right.
However, if the officer orders the soldier to round up 50 unarmed school children, line them against a wall, and execute them,
There is no universe where that is a lawful military operation.
and the law assumes that any human being, regardless of their age, their rank, or their fear of insubordination, possesses a baseline human conscience capable of recognizing that.
Wow.
The text of the law is uncompromising here. It explicitly states that orders to commit genocide or other crimes against humanity are manifestly unlawful.
Meaning a soldier can never stand in front of a judge and claim they thought participating in a genocide was just standard military procedure.
Never. The law demands that you retain your individual moral agency, even in uniform. You cannot outsource your conscience to your commander.
It is the ultimate assertion that humanity supersedes hierarchy.
Well said.
Now, establishing all these rules and liabilities brings up a massive logistical nightmare. We have these ironclad laws, but crimes of this scale often cross borders.
They almost always do.
So suppose a warlord orchestrates a campaign of ethnic cleansing in a foreign country. Years later, The regime falls, they flee, and they somehow end up living quietly in a neighborhood in Manila. What can local Philippine courts actually do about a crime that happened thousands of miles away, involving foreign victims and a foreign perpetrator?
This is where we encounter the concept of jurisdiction in chapters 7 and 8. And the framework adopted here is incredibly expansive.
How expansive?
The state can exercise jurisdiction over these crimes if one of 3 conditions is met. The first 2 are expected. If the accused is a Filipino citizen, or if the crime was committed against a Filipino citizen.
Okay, those make intuitive sense, but what's the third?
It's the third condition that radically alters the landscape. The state claims jurisdiction if the accused, regardless of their citizenship or where the crime took place, is simply present in the Philippines.
Wait, just stepping foot on the soil activates the jurisdiction of the local courts?
Yes. The legal doctrine driving this is universal jurisdiction. The philosophy is that crimes like genocide and widespread torture are so universally abhorrent that they are an assault on the international community as a whole.
So the perpetrator isn't just an enemy of the state they attacked, they are hostis humani generis.
An enemy of all mankind, yes.
It's like the same legal theory that historically allowed any nation's navy to capture and try pirates on the high seas?
Precisely. If an enemy of all mankind enters your territory, you not only have the right to prosecute them, you arguably have a moral obligation to ensure they do not find safe harbor.
Now, the law does prevent diplomatic gridlock, right? Local authorities can opt to extradite the accused to an international tribunal or another state that has a stronger claim.
Yes, extradition is always an option. And they also respect double jeopardy.
Meaning they won't put a foreign national on trial if that person has already been tried by a competent court elsewhere and either acquitted or served their sentence.
Exactly. But if they haven't faced justice, there is a tiny one-sentence provision in this law that is absolutely staggering.
I think I know the one you mean.
It fundamentally redefines the concept of time in the justice system. It simply states that the crimes defined in this act shall not be subject to any prescription.
There is zero statute of limitations.
None whatsoever.
That is mind-bending. Because in standard criminal law, statutes of limitations exist for very practical reasons.
They do. A decade after a robbery, witnesses forget what they saw, physical evidence degrades, paperwork is lost.
The system acknowledges that after a certain point, a fair trial is basically impossible. But under this law, a person could be a frail 90-year-old grandfather living a quiet life 50 years after war ended, and authorities can still kick his door down and put him on trial for a war crime he committed in his 20s.
Yes, and international tribunals have repeatedly demonstrated this by hunting down former concentration camp guards well into their 90s.
Wow!
The philosophical justification for stripping away the statute of limitations is profound. Standard crimes are offenses against an individual or a local community, and society eventually heals and moves on. But genocide and crimes against humanity are attempts to fundamentally break the human species.
So time does not wash away the culpability of exterminating an ethnicity.
It does not. The trauma inflicted by these crimes is intergenerational. To impose a statute of limitations would be to tell the survivors that if a monster can successfully hide for 20 years, their horrific actions are suddenly legally forgiven.
And the law refuses to grant that amnesty. The justice system will never stop looking.
Never. And to ensure the local courts are equipped to handle the immense weight of these cases, the law mandates that domestic judges don't just rely on local precedents.
Right, Section 15. They are legally instructed to integrate international jurisprudence directly into their courtrooms.
So a judge in a regional trial court is suddenly tasked with applying the 1948 Genocide Convention, the Geneva Conventions, customary international law, and the rulings of international criminal tribunals.
It weaves a seamless web of global legal history right into local proceedings, which is an incredible mechanism for accountability.
It really is.
But, in discussing all these mechanisms, the tribunals, the jurisdictions, and the chain of command, it is very easy to lose sight of the people at the dead center of the violence.
You mean the victim?
Yes, the victims. Fortunately, this law includes a deeply empathetic, human-centric framework designed to acknowledge the unique trauma of surviving an atrocity.
And that is so necessary, because testifying in a war crimes tribunal is not like testifying in a fraud case.
No, not at all.
A victim is asked to publicly relive the absolute worst moments of their existence, often involving severe physical and psychological torture. And they had to do it while sitting in the same room as the people who orchestrated their suffering.
The law anticipates that re-traumatization, though, and it mandates that the courts take appropriate measures to protect the safety, physical well-being, dignity, and privacy of victims and witnesses.
And it gives the court powerful tools to achieve that, overriding standard judicial procedures if necessary.
For instance, the bedrock of a fair trial is that it must be public. Transparency is paramount. But this law allows for in-camera proceedings.
Right, in-camera essentially means conducting the trial in private, away from the public gallery and the press.
The court can close the doors or allow a victim, particularly a child or a survivor of sexual violence, to present their evidence via closed-circuit video links.
It acknowledges that forcing a survivor of systemic rape to describe their assault on a public witness stand while staring down a warlord is just an unacceptable cruelty.
It balances the accused's constitutional right to a fair trial with the victim's right to basic human dignity.
Absolutely. The law also addresses the physical danger witnesses face.
Right, the withholding of evidence.
Yes, in cases where handing over the full prosecution, evidence to the defense team would result in the grave endangerment of a witness or their family. Say, if the accused still commands an active insurgent group.
The prosecution can withhold the full documents and submit a summary instead.
Which is a terrifying legal tightrope.
It is. You have to provide the defense with enough information to mount a fair defense, but you cannot hand them an unredacted document that effectively serves as a treasure map for assassins to find a witness's children.
It requires immense judicial discretion to navigate. But the focus on the victim extends beyond the trial itself.
Yes, to Chapter 6, because if a conviction is secured, the court's job isn't finished just by throwing the perpetrator in a cell.
The law establishes a robust system of reparations. The convicted individual can be ordered to pay restitution, compensation, and rehabilitation directly to victims.
I try to visualize this mechanism by thinking of a corrupt, destructive machine.
Oh, I like that analogy. Let's hear it.
So a standard punitive justice system, it just arrests the driver of the machine. But the machine itself, the wealth, the land, the power amassed through the atrocity, it's left intact.
Right, the system stays in place.
But what this law does through the forfeiture of assets and enforced reparations is it completely dismantles the engine.
That is a highly accurate representation of the mechanism.
It strips the warlord of the economic power they violently extracted, melts down the parts of that corrupt machine, and uses those resources to actively rebuild the communities they crushed.
Restitution tries to return what was stolen. Compensation addresses the incalculable moral and economic damage.
And rehabilitation funds the medical and psychological care necessary for survivors to function again.
It represents a monumental paradigm shift. It moves the system away from a purely punitive model, which is solely obsessed with hurting the offender.
And embraces a restorative model, which centers entirely on healing the victim and repairing the societal fabric.
It is a remarkable journey we've taken today, really unpacking all of this.
It is. We started by looking into the primal chaos of the battlefield, questioning if rules could even exist there.
And by unpacking this legal framework, RA 9851, we've seen how humanity attempts to build a sturdy bridge between the highest ideals of international law and the practical reality of domestic courts.
We've explored the meticulous boundaries of conflict, analyzing the psychology of the white flag, and why the weaponization of trust through perfidy threatens the very concept of mercy.
We dove into the physics of expanding bullets, the demographic horror of genocide, and the suffocating limbo of enforced disappearances.
We examined the dark calculus of proportionality when a hospital sits above a munitions depot. We saw how the law climbs the chain of command to hold the CEO of a military accountable,
while simultaneously demanding that an 18-year-old private nurse retain their moral agency in the face of manifestly unlawful orders.
And we observed how universal jurisdiction and the total abolition of the statute of limitations ensure that time and geography offer no sanctuary for the enemies of mankind.
It is a breathtaking attempt to legally contain the worst impulses of human nature.
It really is. But before we conclude, I want to leave you, the listener, with a final provocative thought.
Oh, there we go.
The text of this law explicitly mandates that judges and prosecutors receive specialized training to handle these cases.
Yes, it does.
Because judging the intent of a genocide or calculating the proportionality of an airstrike requires profound human judgment, empathy, and moral reasoning.
It requires a deeply human conscience to interpret these deeply human rules.
But here is the reality we are racing toward right now. Warfare is evolving at a terrifying exponential speed.
That's undeniably true.
We are entering the era of autonomous drone swarms and AI-driven targeting systems.
See where you're going with this.
When a machine algorithm, rather than a human commander, is the one instantly calculating the acceptable collateral damage of a strike. Or when an artificial intelligence misidentifies a white flag or systematically categorizes a civilian demographic as a threat.
How does this carefully constructed framework apply?
Exactly. It is the most pressing legal dilemma of our century. Who bears the command responsibility when the decision to end a human life is made by lines of code?
Can an algorithm commit a war crime? And how do you punish a machine?
It brings us right back to that opening image. We have spent centuries building this incredibly intricate, morally fraught rulebook to restrain the human heart in times of war.
But as the weapons of war slowly lose their humanity, will the rules of war still be able to save ours?
That is the question the world, and you, the listener, will very soon have to answer.
Welcome to the debate. Imagine for a moment that a foreign military commander, someone who orchestrated mass civilian casualties halfway across the globe, just decides to take a vacation.
Right, just a casual trip.
Exactly. 10 years after the atrocities, they step off a plane in Manila. Does a local law enforcement officer have the authority to arrest them for crimes against humanity?
Well, under Republic Act No. 9851, the Philippine Act defining and penalizing crimes against international humanitarian law, the answer is actually a resounding yes.
It is. But, how does a single country cast a legal net over the entire world?
That is the question.
Right. So today we are dissecting this monumental piece of legislation. And our central question is this. Does this legislation establish an absolute, uncompromising framework for individual criminal accountability, or is it fundamentally a pragmatic document structured around legal exceptions and international deferrals?
Yeah, it's a massive topic.
It really is. So I argue that the act represents an uncompromising standard of absolute accountability, targeting everyone from the foot soldier to the head of state without any expiration date on justice.
And I will demonstrate that the act actually reveals a deeply conditional approach, embedding crucial loopholes and immunities that reflect geopolitical pragmatism over absolute justice.
Okay. To really understand the ambition of this text, we have to look at its structural rigidity.
Right.
It's designed to completely dismantle the historical excuses perpetrators use to escape justice. We find the core of this in Chapter 5, which outlines the principles of criminal liability.
Yes, Chapter 5.
Yeah. Take Section 11, for instance, which explicitly mandates non-prescription. This means that the crimes defined under this act, their prosecution and the execution of the sentences, they can never be forgiven by the passage of time.
There is no statute of limitations.
Exactly. If a dictator goes into hiding for 40 years, sure, the evidence might age, witnesses might grow old, but the law itself never expires. It waits. And, it doesn't care about your rank either. Section 9 enforces the irrelevance of official capacity. It explicitly states that being a head of state, a member of government, or an elected representative offers zero exemption from criminal responsibility.
It casts a wide net.
It does. And to close the loop, Section 10 establishes the responsibility of superiors. It holds commanders liable not just if they actively ordered a massacre, but if they simply, quote, should have known their subordinates were committing atrocities and failed to stop them.
Right, taking away the plausible deniability.
Exactly. It strips away that classic defense. That architecture, to me, is what I call absolute accountability.
Well, the text certainly uses uncompromising language when setting up the rules, I'll give you that. But when you examine how those rules operate in the real world, you see explicitly engineered escape valves woven into those exact same chapters.
Escape valves?
Yeah, you brought up Chapter 5, so let's look at the mechanisms right next to the ones you just mentioned. The law asserts absolute accountability, but then it introduces Section 12, which is the orders from a superior defense.
Okay, but
let me just finish this thought. This legally relieves a person of criminal responsibility if they were legally obligated to obey an order and, importantly, did not know that order was unlawful.
Right, but there are caveats to that.
There are, but let's also look at official capacity. Section 9 contains paragraph B, which quietly preserves the, quote, immunities that may be attached to the official capacity of a person under international law. I mean, that is a massive concession. It shows the act is built to bow to international political reality, aiming to survive the friction of global diplomacy rather than enforcing blind absolute justice.
Okay, I see why you think that. But let me give you a different perspective on Section 12 and the superior order's defense.
Go ahead.
You're framing it as an escape valve, but you have to read the entirety of the provision to see its teeth. Section 12 is actually exceptionally strict.
Strict how?
Because it explicitly declares that orders to commit genocide, which is found in Section 5, or other crimes against humanity found in Section 6, are, quote, manifestly unlawful.
Right.
By defining them this way, the act completely neutralizes the defense for the most heinous atrocities. I mean, if a soldier is ordered to participate in the systematic extermination of a demographic group, they cannot stand in front of a judge and claim they didn't know it was unlawful.
Yeah, I agree with that part.
The law preempts that excuse entirely. It's structural genius.
I'm sorry, but I just don't buy that. Let me tell you why. You are absolutely right that Section 12 neutralizes the defense for genocide and crimes against humanity. But notice what is conspicuously missing from that absolute rule.
What?
Section 4, war crimes. The Act specifically omits war crimes from the presumption that such orders are manifestly unlawful.
Wait, let me make sure I'm following your critique here. Are you suggesting that leaving war crimes out of that specific clause was a mistake or like an intentional loophole?
I'm suggesting it acts as a massive evidentiary loophole for the military.
Because there is a very functional, operational reason for that omission.
Well, let's look at the mechanics of Section 4 first. It defines war crimes as including actions like launching an attack in the knowledge that it will cause incidental loss of civilian life that is excessive to the military advantage.
Right. Proportionality.
Exactly. Or attacking what the law calls a non-defended locality, essentially an unfortified civilian-populated area.
Sure.
Now put a subordinate pilot in the cockpit. They receive coordinates over the radio from command. They drop a payload. It turns out those coordinates were a non-defended village.
Okay. Tragic. Yes.
Because war crimes are not categorized as manifestly unlawful, that pilot can successfully argue under Section 12 that they were legally obligated to obey command and they lacked the specific intelligence to know the tactical order was unlawful. The defense remains fully intact for a vast category of battlefield atrocities.
But we have to distinguish between an intentional loophole designed to let people evade justice and a necessary legal mechanism to establish mens rea, meaning, the criminal intent, the guilty mind.
But the outcome is the same.
Not in criminal law. You cannot have a functioning system of justice if you penalize a private or a corporal for lacking the strategic, classified intelligence that only their commanding general possesses.
I see your point, but
The reason Section 4 isn't included in the manifestly unlawful presumption is because the fog of war is real. Distinguishing a legitimate, camouflage military target from a civilian object often requires satellite data and intercept communications that the instrument, the pilot, just does not have.
that's fair.
If the soldier genuinely believes they are striking a military objective because their chain of command told them so, how can a court say they possessed a guilty mind?
Because the end result is the same. A village is destroyed.
Yes, but criminal liability shouldn't rest on the person who was kept in the dark. It should rest on the person who turned off the lights.
Oh, that's a clever way to put it.
Thanks. And that brings us right back to Section 10. The commander is held liable under the doctrine of superior responsibility. The accountability doesn't disappear into the fog of war. It simply shifts up the chain of command to where the actual intelligence resides.
It shifts up the chain, assuming you can prove the commander knew or should have known and failed to act.
Which the law allows for.
Right, but by severing the liability at the subordinate level for war crimes, you make the prosecution of those crimes exponentially more difficult.
It is difficult, yes. International law is difficult.
Proving the mental state of a superior, documenting what they knew and when they knew it across complex communication networks is notoriously the hardest thing to achieve in international criminal law.
True.
So the pragmatic reality is that by leaving war crimes out of that absolute presumption in Section 12, the state has built a highly pragmatic shield for its own armed forces during complex conflicts. It protects the foot soldier and places the burden of proof on the hardest possible target, the general.
I think we'll have to agree to disagree on whether that constitutes a shield or just proper judicial rigor.
Fair enough.
But let's follow that logic up the chain of command. If we accept that accountability shifts to the leaders, we immediately crash into your second major contention, official capacity and immunity under Section 9.
Yes, let's talk about Section 9.
You suggested earlier that preserving international immunities makes the law conditional. But look at the domestic implications first. Section 9 explicitly strips domestic immunity.
Domestically, yes.
Under this law, no domestic official, regardless of their rank or popularity, can use their office to block prosecution. Think of Section 9 and Section 11 as a permanent mechanistic foundation.
A foundation.
It functions like an anchor, holding the entire concept of human rights in place by ensuring nobody domestically outranks the law and the law never expires.
It functions like an anchor for domestic actors, absolutely. But let's talk about the chain we attach to that anchor.
Okay.
Section 9, paragraph B explicitly says that immunities attached to the official capacity of a person under international law may limit the application of the act.
Yes, it does say that.
This creates a deeply pragmatic two-tiered system of accountability. A domestic warlord or an internal rebel leader faces the full, unyielding force of the law.
As they should.
Absolutely. But what if the perpetrator isn't from here? What if a visiting foreign head of state or a high-ranking diplomat funded, orchestrated, or directed proxy violence that constitutes a crime against humanity?
Well,
under the Vienna Convention on Diplomatic Relations, they have diplomatic immunity. Section 9, paragraph B honors that. They are legally shielded from Philippine jurisdiction.
wait, I want to pause on that because I think we're conflating the text of this specific act with the entirety of global governance.
How so?
You're calling it a concession, but a single domestic law cannot unilaterally rewrite customary international law regarding head of state immunity.
I'm not saying it should rewrite it.
But if the drafters of Republic Act 9851 decided to ignore the Vienna Convention, what happens? The law gets struck down as unconstitutional, or worse, it triggers massive diplomatic crises, embassy closures, and economic retaliation.
Exactly.
Acknowledging the immovable realities of international law doesn't make the domestic accountability framework any less absolute for those within its rightful jurisdiction.
But you are making my exact point for me. The act does bow to international realities. It does avoid triggering diplomatic crises. That is the very definition of a pragmatic document.
I wouldn't say it bows.
If the framework were truly uncompromising, it would assert universal jurisdiction without caveats, forcing the courts to clash with international norms in the name of absolute human rights.
That would be reckless.
Yes. The drafters knew better. They carefully stepped around the toes of the international community. The law essentially says, we believe in absolute justice, unless you hold a specific diplomatic passport, in which case we defer to the global status quo.
I disagree that deferring to international law is a failure of the Act's absolute nature. It's simply an alignment of jurisdictions.
An alignment?
Yeah. And speaking of how jurisdictions align, this brings us to what is arguably the most radical and ambitious mechanism in the entire legislation. Section 17.
Section 17.
The mechanics of jurisdiction here are breathtaking. The state claims jurisdiction over these crimes if the accused is a Filipino citizen, or if the crime is committed against a Filipino citizen.
Right, standard jurisdiction.
But the critical part is the third condition. The state claims jurisdiction if the accused, regardless of their citizenship or where the crime occurred, is merely present in the Philippines.
Yes, the assertion of universal jurisdiction.
Exactly. Let's go back to the scenario we opened the show with. If a foreign national commits a war crime in a completely different hemisphere against other foreign nationals, and a decade later they transit through Manila, the state asserts the legal right to arrest and prosecute them.
It's a huge claim.
This is a bold, uncompromising assertion of global accountability. The state is taking on the immense burden of prosecuting the enemies of all mankind, acting as a global police force when a perpetrator crosses its borders. how can you look at that mechanism and see anything other than an ironclad commitment to absolute justice?
That's a compelling argument, but have you considered the very next paragraph of Section 17?
Paragraph 2.
The text says, quote, "In the interest of justice, the relevant Philippine authorities may dispense with the investigation or prosecution if another court or international tribunal is already conducting the investigation."
Right.
And it continues to outline that the authorities may simply surrender or extradite suspected or accused persons in the Philippines to the appropriate international court or to another state.
Which is a necessary traffic control system. It prevents double jeopardy and respects international tribunals like the ICC.
It is a traffic control system, but look closely at the operative word, may. The authorities may dispense with the investigation.
Discretion is standard in law.
Think of Section 17 like a pressure release valve on a massive industrial boiler, asserting universal jurisdiction over anyone who steps off a plane builds immense diplomatic and logistical pressure.
It does, yes.
Conducting a trial for a genocide that occurred in another country is a nightmare. You have to fly in hundreds of witnesses from halfway across the world, secure their safety, translate thousands of documents, and navigate the immense geopolitical blowback from the perpetrator's home country.
It's a heavy lift.
It is financially and politically exhausting for any domestic legal system. Section 17, paragraph 2, is the pressure valve. It gives the state a perfectly legal mechanism to wash its hands of politically sensitive or financially burdensome prosecutions.
Wash its hands?
Yes. They can make the arrest, secure the headline, and then quietly extradite them or defer to an international tribunal that might take years to act.
If you're listening to this and thinking, why on earth would a country just pass the buck on a war criminal? It's vital to understand that extradition isn't letting someone go free.
Well, no, but
It's ensuring they face a competent court that might actually be better equipped to handle the evidence. If the crime happened in another state, that state likely has better access to the crime scenes, the forensic data, and the victims.
that is generally true.
Right, so Section 17 isn't an off-ramp designed to avoid justice. It's designed to ensure justice is delivered in the most effective venue possible. The text explicitly states this deferral is in the interest of justice.
But in the interest of justice is one of the most flexible phrases in the legal dictionary.
Oh, come on. It is. It allows the executive branch or the Department of Justice to make a purely political calculation. Imagine a scenario where prosecuting a specific foreign national would jeopardize vital trade relations or a critical military alliance.
That's a cynical read.
It's a realistic read. The authorities can use Section 17 to defer the case, claiming it's in the interest of justice to let someone else handle it. An absolute, uncompromising framework wouldn't leave that to administrative discretion. An absolute framework would mandate domestic prosecution if the evidence meets the threshold, period.
But if we mandate domestic prosecution without considering the existence of other active investigations, we risk sabotaging the entire machinery of international justice.
How? We run into double jeopardy issues, which the Act strictly prohibits. If a person has already been tried by a competent court outside the Philippines, they cannot be tried again. This entire chapter is about integrating the Philippines into a global network of accountability.
Integrating, sure.
It's not washing its hands. It's playing its necessary part in a synchronized global effort.
A synchronized global effort that relies heavily on diplomatic tact. If we step back and look at the broader picture of how this act operates, a pattern emerges.
Let's hear it.
You have Section 12, which protects subordinates under the chaotic conditions of the fog of war. You have Section 9, which honors the diplomatic immunity of international actors. You have Section 17, which provides a legal mechanism to pass the baton when a case is simply too hot or too expensive to handle domestically.
They are practical provisions, yes.
Every single one of these provisions is profoundly rational. They're designed to prevent the Philippine judicial system from collapsing under the weight of impossible international prosecutions or accidentally sparking international conflicts.
Right.
I am not arguing that the law is bad or ineffective. I am arguing that it is fundamentally a pragmatic document. It operates in the messy real world where the pursuit of justice has to be constantly balanced against state survival, logistical limitations, and diplomatic friction.
And I maintain that recognizing the messy reality of the real world does not compromise the absolute nature of the standard this legislation sets.
The text is a triumphant codification of accountability. By asserting universal jurisdiction in Section 17, by completely removing statutes of limitations in Section 11 so that justice can never expire, and by rigidly codifying command responsibility in Section 10, Republic Act number 9851 ensures that impunity is structurally dismantled.
It certainly aims to.
The law ensures that there is no safe harbor, no timeline to outlast, and no domestic rank high enough to shield a person from the reach of human rights law. The fact that it coordinates intelligently with international bodies doesn't make it a sieve. It makes it a larger, stronger, more interconnected net.
Well, I think we can both acknowledge the sheer scale of what this legislation attempts to accomplish, even if we view its structural integrity differently.
Absolutely.
To take the incredibly complex, sprawling nature of international humanitarian law, drawing from the 1907 Hague Conventions, the 1949 Geneva Conventions, and decades of customary international law, and meticulously incorporate it into a functional domestic legal framework, is a monumental legislative task. It is attempting to translate global moral imperatives into local police action.
It truly is. The Act takes these lofty, often abstract international principles and gives them real teeth within a national penal system. It defines highly specific horrors of war crimes like perfidy, which is faking a surrender to launch a surprise attack, or forced pregnancy, with a precision that deeply honors the dignity of the victims of armed conflict.
Yeah, the specificity is impressive.
It forces a domestic legal system to look outward, beyond its own borders, and accept a share of the burden for humanity's collective security.
And in doing so, it forces us to ask the hard question of how much of that burden a single state can truly bear before it has to introduce the friction of geopolitical reality. To catch a war criminal, a single nation has to legally pretend it has the authority to police the world, while politically knowing it doesn't.
Which brings us back to where we started. When dissecting a legislative text of this magnitude, we have to consider how a state balances its highest moral imperatives with the mechanics of legal pragmatism.
It's a delicate balance.
It is. We invite you, the listener, to explore the parameters of Republic Act No. 9851 for yourself. Look at the definitions, trace the chain of command liabilities, and examine the universal jurisdiction.
Read the actual text.
Exactly. Decide for yourself whether this law represents an ironclad net capable of catching the perpetrators of the world's worst crimes, or a flexible legal sieve intelligently designed to let the realities of global geopolitics flow through.